Gated on the basis of a mandate given by the Constitution.
Thank
ये भी
you.
exactly यही कह रहा है.
Thank you for pointing out. Let me again, in relation to this judgment also, now clarify what this judgment has actually said and what it is purportedly argued that it has said.
No, argument apart, as
Sir,
Ladyship also pointed out, and as has been mentioned earlier, the judgment that you rely upon in itself lays down this, the ratio of the judgment is that the rule-making power, when exercised, when the rules are framed, then such rules stand on a higher pedestal for the reason that those rules have been framed in exercise of powers granted by the Constitution itself. And the powers granted by the Constitution under 191 are the powers granted by the Constitution to the Supreme Court and not to any other organ of the state.
My Lord, if we can just see page 536 of this judgment on this point alone.
Before you come to 536, just one quick question. This sentence that you have read out to us from page 523,
Yes.
which you regard as critical, is it your understanding that this is part of the ratio of the judgment?
Yes.
This is para 25 head note K जो है ना आपका इसमें पढ़े ही नहीं. In fact, the word subject to the provisions of any act उसको define किया है उन्होंने.
जी सर मैं
बिंडर वाले केस में.
हाँ मैं एक सेकंड
जाहिद साहब आप चले आर्ग्यूमेंट तो अपना करें ना.
जी जी जी. So I was trying to yes, page 536 of the judgment, my lord, of the same judgment.
Mr. Zahid,
जी पढ़िए.
para 36 is more relevant.
सर मैं उसी पे आऊंगा सर अगर एक सेकंड के लिए. ये हायर पेडेस्टल वाली जो बात है 530 पेज 536 पे फर्स्ट पैराग्राफ. The Supreme Court rules are on a higher pedestal and promulgated on the basis of mandate given by the Constitution itself and not by a government, object whereof was to enhance the power of review as conferred upon the Supreme Court under Article 188 of the Constitution. One more time, just the first part. Supreme Court rules are on a higher pedestal. Higher pedestal than what? ये इसके जो preceding paragraph, preceding page है, अगर हम उस पे जाते हैं,
इसलिए कहा है कि रिव्यू में पावर बढ़ाए में रूल्स ने.
सर इसमें ये
I'm trying to understand, Mr. Zahid Ibrahim. Please, can you complete your thoughts? Take the questions, note them. You keep responding to every query. I don't know what you're going to say next.
Okay, my lord. All I was the point.
You were on 236 AA.
The
Yes.
point that I'm making is that in this judgment, when the Supreme Court says that the rules are on a higher pedestal because they are made under constitutional sanction, what are they saying? Higher pedestal than what? Higher pedestal than law or something else? They are saying higher pedestal than rules made on the basis of another statute.
No.
And if I may just complete, I will complete.
If you would also read the NRO judgment, this point has further been elaborated by this court by saying once these rules are made, any subsequent legislation we may not follow. And we need not follow.
मेरी सिर्फ आपसे ये गुजारिश है कि यहाँ पे जो conclusion हुआ है full court का in relation to the Supreme Court rules being on a higher pedestal, that is not on a higher pedestal as compared to any law. And the reason why I say this is evident because this discussion started from page 500.
Can you just complete your thoughts?
Page 534 at the bottom of page 534.
Para 37.
Para 37, my lord. Exactly.
So Zahid, para 36 is very important.
चलिए जाहिद साहब please argue करिए as you want to.
So para 37 का ये
जाहिद साहब अगर मैं आपसे सवाल ऐसा पूछूं जिससे मैंने फैसले ही कर रहा हूं तो आप कहें फिर सवाल ही नहीं बनता है. आप अपना आर्गुमेंट कर लें कंप्लीट फिर हम आपसे सवाल पूछ लें.
I mean, I honestly feel that today, I mean, I'm trying to answer questions.
आप पहले आर्गुमेंट अपना कंप्लीट कर लें ना.
They help in this debate.
जी.
So I was just wanting to read para 37 from the bottom. मतलब जो in Roman font है उससे पहले वाला एक sentence. A line of distinction. In this regard, reference may be made to the case of Federation of Pakistan, Saeed Ahmed, PLD 1974. A line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of Constitution as conferred upon it by Article 188 of the Constitution. ये जो sentence है, my lord,
A line of distinction.
a line of distinction is to be drawn between statutory rules made by the executive pursuant to an act or an ordinance and statutory rules made by the Supreme Court pursuant to the mandate of the Constitution as conferred upon it under Article 188 of the Constitution. That is what is being.
But if
Ajay, can you now go back to 536 AA?
if this line of distinction is drawn, Mr. Zahid Ibrahim, if this line of distinction is drawn,
Yes.
that which means that the rules made under 188 are of a different category altogether, then there's no need to say that those rules are at a higher pedestal. Then those rules and rules made which are normally called subordinate legislation fall into two different categories. It seems to me that the passage, that those words that you have just read out from page 536 on a higher pedestal is not vis-a-vis a category that the Supreme Court in the words that you have just read out
My lord.
say fall into a totally separate and distinct category. And if this is correct, then the higher pedestal can surely be only vis-a-vis law and not subordinate legislation or rule-making power, which is of a totally different nature. Would that not be a proper reading of the judgment as a whole?
Perhaps, like the first sentence of paragraph 37, in fact, perhaps answers what your lordship is saying. Supreme Court itself says, in view of the above discussed principles of interpretation, it seems immaterial to discuss whether the Supreme Court rules are subservient to Article 188 of the Constitution. They say that is an immaterial argument. Pedestal, that is only in relation to rules made under some other statute.
ठीक, चलिए,
That is the point.
आगे बढ़ें,
जी,
बढ़ें.
जी, my lord,
And
in relation,
if we go back to 536 AA,
Mr.
now if we are to read this line disjunctively, object whereof was to enhance the power of review as conferred upon Supreme Court under Article 188 of the Constitution, then if you go to read it like the petitioners want us to read it, that would mean that the Supreme Court is not bound by Article 188 either, because it's giving it more power than the Constitution itself. Surely that cannot be the case. So it has to be read in context to the line that you read. I don't know.
I understand that, we are all pressed for time. I don't want to sort of.
हम पढ़ लेंगे पूरा judgment.
Ji, my lord, the next point I want to make is in relation to appeal.
But before you go to appeal,
Entry
before you